Okay, I think we'll take this opportunity to get started. So, welcome everybody, and thank you for joining our webinar this morning, which is on a data breach survival guide. It's going to be a very practical Q&A session that we're going to have this morning. So, with no further ado, I'd like to introduce our two speakers. We have Bill Fragos, who is with Moray and Agnew, who is special counsel and a commercial lawyer, who's going to give us some really great insights today on how to navigate and survive a data breach, and also some really sound advice about preparing. And also we have Christian Piquetta from Netway Networks, who's our operations manager, who's going to talk a little bit about how you can best prepare yourself and protect your business. So it's going to be really a great conversation today, and we look forward to your input and your questions. So please pop them through. My name's Sonia Tamaro. I'm the People and Culture Manager at the Knorrs Technology Group, and it's my pleasure to be the host and facilitate this really great discussion today. So hello, Bill, and hello, Christian, if you want to give us a wave.
Hey guys.
Sonia.
Awesome. So the Office of the OAIC, which is the Australian Information Commissioner for Information, in 2023 reported that in the first half there were 490 data breaches. 60% of those were malicious and 33% of those were due to human error. In the second half of the year, we saw another 483 incidents reported. So there was a 19% rise in the second half of last year. So increasingly, this is becoming a problem, not just obviously for Australian businesses, for global businesses as well. And the webinar today is going to address what you do if you are a victim of a cyber attack, and most importantly, how to prevent that from happening and the steps that you can take to put yourself and your team and your customers' information in the best position that you can. So we're going to start with our first question for Bill. So Bill, welcome. And could you please just provide our audience with a general overview of what the definition is of a data breach?
Thanks for that, Sonia, and thanks to everyone for joining us today. The Privacy Act and the privacy principles can be breached generally, so there's increasing requirements across that framework for a breach. Specific to data breaches, we're looking at unauthorized access to or disclosure of personal information. So that could be ransomware, it could be wrong recipients, it could be people within your organization not entitled to look at the information. It could be things as innocuous as continuing OneDrive access to a person after they've been, say, removed from a particular project. It also can mean a data breach can be information that is actually lost in certain circumstances. So a lost USB or external hard drive, even a phone. Now, hopefully people password protect their phones, but there is still nevertheless a lot of information that resides on certain tech equipment like phones and laptops, and especially in relation to phones, some of it may be accessible anyway, irrespective of whether it's password protected. So in summary, unauthorized access or disclosure of personal information, and secondly, information lost, where it's likely that someone's going to access or have access to that information.
Thanks, Bill. I mean, it's interesting that it's not just necessarily the big scale attack. It can be something as simple as losing, a USB or a phone. Can you give us some insight into some of the legal implications of a data breach or a cyber attack?
I suppose it comes twofold. One is dealing with regulators and your individuals affected by it. So when there's a data breach, if it results in meeting the threshold or likely to result in serious harm, you actually have to report it. So not all data breaches will result in serious harm. And so if it's likely to result in serious harm, you have to report that fact to the regulator, the OAIC, as well as the affected individuals. And there's a whole framework surrounding that reporting regime, which I suppose we can get into later on. So there's that. And dealing with regulators and dealing with individuals can be quite cumbersome, administratively intensive. It can be quite costly for a business. Frequently on data breaches that my clients have experienced, even for a routine kind of innocuous kind of data breach, you might be looking at costs of $50,000 to $100,000 for all the questions that the OAIC might have. On the other side, there's the civil obligations that you have. That is, it may be that you have obligations to a particular entity under contract. So say you are receiving information from a particular entity or a government department and you're processing that information, you're handling that information, you may have a contractual obligation to notify that particular party that you've suffered a data breach. And that might lead to a breach of contract. There might also be allegations of, misleading conduct or duty of care, negligence type of situation. So there may also be commercial consequences to a particular business in the event of a data breach. So in that respect, you've got the regulator, you've got individuals, as well as people that you have entered into contracts with that may need to be managed.
Thanks, Bill. I can imagine that within the first 24 hours of a cyber breach occurring or a cyber attack occurring, it would probably be quite chaotic. Can you, talk to us about that first 24 hours and how you would minimise the damage, but also be ensuring that you're doing exactly what you said, meeting your obligations, both to your customers, your contracts, and to the regulators?
Look, I mean, any data breach is going to be very difficult to navigate. Let's just use an example of something fairly kind of over the last year or so. There was two examples, say the CrowdStrike incident or the Optus incident from about a year ago, where not the data breach, but where they were down for a day. You can see how debilitating that could be to you as an individual, to you as a business, and how it's a cost to the business, how you can't do certain things. And that gives you a flavor of the difficulties that you have in trying to manage a data breach. The advice that I generally give to the clients is the first 24 hours will become a lot more manageable if you do certain things beforehand to not only minimize the risks, and there's cybersecurity training and all that, but there's also the information audits that a lot of businesses don't seem to focus on. So if you cut down the information that you hold and minimize the information that you hold, you destroy, delete once you've used it, it's no longer necessary to have it, you don't have a purpose for retaining that information, then you should get rid of it. The reason why those information audits are important, because when you deal with a data breach, the subset of information that you're dealing with is contained, or it could be a lot smaller if you've undertaken that information audit. But going specifically to your question, one of the challenges in the first 24 hours, and hopefully businesses have a data breach response plan in place, is basically pulling together all the relevant stakeholders. I think that's the fundamental part of it, and that's everyone from the executive to your comms and PR. They're often overlooked in a data breach. So what messages you put out, and one of the things you might recall when Optus was down for a day, they were criticized about their lack of communication, ironic because they're a communications entity. And then pulling in your IT people internally, as well as your external IT consultants. Also, as part of that, obviously, there's lawyers and other middle managers that might be pulled in, but having those stakeholders consulted and having a means of communicating with them is vitally important, because it may be, for example, if you've got ransomware, that your typical forms of communication with each other are no longer accessible. So you may need to have either phones it may need to be, and a lot of businesses, mind you, now are integrating their phone systems with Teams, for example, as managing that. And Christian can speak to that, no
I
doubt.
was just about to ask Christian, actually, from an IT department, Christian, those first 24 hours are pretty critical. What role can your IT team play in making sure that you're ready?
Yeah, so ideally you want to be prepared for an incident before it happens, but sometimes that's not the reality of the situation. And a lot of the times we find ourselves in situations where a client has just been blindsided and has had one of their users uh, either passwords compromised or clicked on an email they shouldn't have. Um, in those situations where a breach has been reported or an incident has been reported, the first thing to do is make sure that you isolate the machine. And that includes unplugging it from the network. But more commonly is sometimes people unplug the PC from the network, but they still have wireless. So you want to make sure that you disconnect the wireless as well
That's
to
a
make
good
sure
one.
that to make sure that the PC has been isolated. Another thing is to not turn the PC off. If it's disconnected from the network and it's not communicating to the rest of the environment, don't turn the machine off, because when you turn the machine off, it could potentially erase data that we won't be able to recover if we power it back on. And say it's a virus or something, it could corrupt some of that data. So that's important. In terms of what Bill has mentioned about creating an incident response team and having the right people in place, things that you should think about are people like your HR department, your legal departments. If you have an incident response team at hand already from a technical side, a forensics team, um, and also being able to know what you need to tell your employees about how to communicate a breach to your clients. The one thing about a breach is that it's a discovery process, and at first we have to figure out what the extent of the damage is to that incident. So having a way to communicate to clients or instructing your employees on what to communicate to make sure that it's planned and it's targeted messaging to ensure that what you're communicating is not only honest, but is also protecting you as a business as well, when it comes to what an incident is. And as that incident evolves and you find out what that impact is, obviously continuing that line of communication. Another thing that Bill mentioned, which I agree with, is that not all lines of communications is going to be available. Sometimes you might have an IT guy that's on holiday. So what do you do if an incident happens during that time? Or your vice president might be unavailable for whatever reason. So having a set communication plan in place is very important, not just for how you communicate from your business to your clients, but also internally how you coordinate messaging. One of the biggest challenges with an incident in terms of communication is making sure that the information that's being communicated is accurate. Sometimes people during an incident can be quite stressful, and they start to get into a cycle of speculating. Could be this, could be that, and it could sometimes often lead to targeting your focus on the wrong thing. So making sure that you have accurate, that everything that your team is saying is either confirmed, or that it's not just left to speculation. That you have a very evidence focused approach to how you working through that.
Yeah. Thank you, Bill and Christian. I think certainly thinking about that first 24 hours is really critical, and being as prepared as you can is the key takeout from there that we've had. And I'm sure if we've got more questions in this particular area, we can address them during our Q&A session at the end. I've got a question about the recent cybersecurity bill that was passed last week. Bill, what do our audience need to know about the implications of that?
I'll leave a lot of the technical to Christian, but what jumped out for me regarding that particular bill, it hasn't passed yet, it hasn't been implemented, and obviously there'll be a process before, and an education process before it's actually implemented. But what stood out for me was the ransomware aspects. A lot of our clients have suffered data breaches in the past as a result of ransomware, and a lot of that process was done without consultation to authorities. That is, you have no existing obligation to necessarily report whether a ransom, whether it was what the amount of the ransom was that you paid. The OAIC have always asked that question, and a lot of parties seem to avoid answering that question. What the bill seeks to do is make it an obligation for you to report if it was a ransomware attack and you've paid a ransom, the amount of the ransom, who you've paid it to, and all sorts of other information in relation to the ransom. That information is effectively quarantined. It's going to be provided to the security services part of our intelligence framework. So it's not something that would be used. It will be quarantined from, say, civil liability and from other investigations, but it will be used by the intelligence community to see if there's a pattern of conduct, if there's particular groups that are responsible for those particular ransoms that are being, or those ransomware attacks. And they often the terminology they often give to them is either APTs, advanced persistent threats, or there are certain groups in certain parts of the world that they know are generally responsible for the large-scale ransomware attacks. So it's more of an intelligence gathering exercise and using the information for that purposes. So for my clients who have suffered ransomware attacks, if they occurred in future, there would be a slightly different reporting framework and an additional obligation that would apply to them.
All right. Thank you, Bill. Thanks for explaining that change. A reminder again, if anyone has any questions, please pop them in the chat, and they'll be anonymous, and we can address them a little bit later on. The next area I'd like to ask you both about is, and particularly Christian, is cyber insurance. It's increasingly prohibitively expensive, and I understand there's certain things you've got to do in order to be covered with this type of insurance. Can you comment on that and how we can best prepare and be in the best position to get insurance?
Yeah, but before I do, I just wanted to point something that Bill mentioned. One thing that I did notice from that bill as well is the reporting doesn't seem to be obligatory if you don't pay a ransom. And often people find themselves having to pay a ransom when they don't have adequate backups in order to recover their data. So the bill doesn't really highlight that sort of situation. And whilst Bill says that there is that reporting kind of makes you gives you a bit of immunity, it's no guarantee that it will not be used by another department within the organization. So it's something to keep in mind as well. Obviously, the best approach is to avoid those situations altogether. And the way that you would do that is through implementing stronger security controls in your environment. Tailing off the back of that, with insurance, that also applies. The stronger your cybersecurity posture is, the easier it's going to become to insure. Cybersecurity insurance is starting to dictate some of the things that businesses need to do with their own IT infrastructure in order to meet the requirements for protection. And the thing is that cybersecurity is more of like a risk transfer sort of situation, but that doesn't necessarily cover all bases of your organization. You still need to have adequate governance, and you still need to have adequate security measures in place. And that's partly what the Essential 8 is designed to do. So the Essential 8 has 3 different maturity models. The first maturity model is very basic in terms of, do you have backups? Do you update your desktops? What sort of applications do you allow your organization to install? Can your staff install applications? There's 8 different categories. And the maturity models are based on the idea of very basic is 1. And then say maturity level 3, you might have more advanced technologies in place that are going to help enforce those backups. So in a maturity level 1, you might have, I back up to a hard drive that I take home. Maturity level 3 for that would be, I have a backup that I take home, I have a backup that's stored in a different location, and I've got a cloud provider that's also got a copy of my backup. So that's sort of explains the different types of maturity controls that are in place. But the more you're aligned with Essential 8, the easier it's going to be to ensure your organization.
Okay. Thanks, Christian. Bill, did you have anything to add to that?
No.
No, you're good there? All right. Bill, you touched on this briefly when we started, but how do you know if you actually have to report a data breach? What is the criteria? Who do you report it to? What time frame do you have to report it within? There's a few double-barreled questions there.
So I made reference to the threshold before, which is it's likely to result in serious harm.
Yes.
So when we deconstruct what means serious harm, we're looking at it could be reputational, psychological, financial harm, emotional harm. It's quite broad.
Yes.
So from a practical perspective, the regulator seems to try and take a wide interpretation as to what constitutes serious harm. And obviously, other entities generally try and interpret that it's smaller and not report it. Where the tension comes is where there's usually in a data breach, there's multiple parties involved. So, for example, contractors, and one contractor will report the data breach, whereas the other party will not, and that creates a bit of a tension as to the OAIC making a decision as to whether it constitutes serious harm. The assessment of that as well is also has regards to the kind of information and the sensitivity of the information involved. There's also considerations regarding the security measures that are in place. The thing that trips up a lot of parties and a lot of individuals is the assessment of whether it's likely to result in serious harm is a reasonable person test, but in the position of the entity that suffered the data breach, which is, so there's an objective element to it, but there's a slightly subjective element as well. What we often fight about in terms of whether it's reportable or not is we've had a few data breaches where there might have been access, but we can tell that there's not been any exfiltration from a system. What I mean by that for a lot of people is whether, for example, you upload something to OneDrive or some kind of other network, you make that document or that folder accessible to a particular email address, and that email address is wrong. Now, that person who has that email address would have received the message, but if there's no evidence whatsoever that that folder was accessed or downloaded, would that be a data breach? Clearly, it wouldn't. If it's not been accessed at all, it wouldn't be a data breach. It gets a little bit trickier if there has been an intrusion into the system, but again, we can't see any exfiltration, any data getting exported out of the network. And this often becomes a debate that's had with the regulator in that instance. That is, well, yes, someone might have entered the network, but did they access a particular document containing personal information, which is part of the threshold. It's the data breach necessarily involves the access of disclosure of personal information. So it's not enough to say someone's actually entered the network. It's a little bit more precise than that. It's whether they've actually accessed or had the information contained in a particular documents, personal information contained in those documents, has either been accessed or disclosed or otherwise lost. So,
Hey, Bill, sorry, just to ask, in that scenario where there is a data breach and you do have cybersecurity insurance in place, what sort of protections does that allow to, say, directors and owners in terms of liability? Does that change the liability at all, or?
yeah, I mean, a lot of directors and officers have D&O policies, directors and officers insurance. So hopefully there's a policy that responds there if they've done something wrong. And then there's obviously other insurance policies that might apply in addition to whether the business has obtained cyber security insurance. So in that instance, if you're trying to hold a particular person within an organization liable, I've not seen the regulator take that approach to date. In fact, they've only taken half a dozen cases before the courts. And in terms of the inquiries that are made in terms of data breaches, they haven't really looked at analysing individual directors or officers' conduct in relation to a particular data breach. It might be relevant when it comes to a commercial contract between parties where there's a responsibility to notify the other party in the event of a data breach. And then questions are asked, well, how did this data breach happen? The regulator is still going to ask those questions, but the other party might ask and might seek discovery of that particular information to try and identify particular individuals and whether they were adequately trained and whether they took due care, and try and hold them liable in addition to the company. It would be a strange situation, though, because you would have to show that they acted in a way outside of the scope of their authority or outside of what the normal conduct expected of people in that position. And that would be a little bit difficult to hold them personally liable. But in any event, if they are a director or an officer, you'd think that a D&O policy would also kick in, so long as they haven't been engaging in some form of criminal conduct which would void such a policy. So I know there's a lot to unpack there. There is a theoretical risk to individuals within an organisation, but to date we haven't seen it.
Okay, thank you, Bill. Before we sort of move to the general Q&A component, one more question for Christian. It feels like going through a cyber attack would just be so enormous. If an organisation has actually been through it once, what can they do to make sure it doesn't happen again?
Yeah, so cybersecurity incidents can be quite traumatic, to put it plainly. To some degree, it's a high-stress environment. In terms of getting prepared, anything that you have ahead of time that's already fleshed out and thought about and thought through beforehand is going to only help in not just the speed of recovery, but also in how you guys conduct yourself in terms of during that incident. So the advice that I would give is three things. So the first one is to form a business impact analysis. And what that is trying to understand, what assets in your organization are most important. And by that, I mean, what information is the most sensitive? What systems do you need to maintain service levels for your clients? Is there relationships between those assets and other assets? And how would that going down impact this thing going down on that other side? So having that is going to then help inform a business continuity plan. And the whole point of a business continuity plan is to put in place redundancies in areas that are critical to your business. So knowing how long you can be out, or how long a system can be out, or how long you can stop doing business, or be ineffective to a point where it's now your business is in danger because you can't recover from it.
Oh, right.
Knowing the maximum tolerable outage that you can afford before it starts to really harm your environment is going to inform not just your continuity plan, but it's going to inform your response plan as well. What sort of responses, where your efforts are going to be directed at, in order to make sure that you could get up and running as quick as possible. An incident response plan also has a lot of the other stuff that we've mentioned: communication plans. It has the priority of the assets and what the responses are, and the severities, what the different categories of severities, how you contact, who you contact, when you contact, and what sort of medium you're using for that, as well as what your targeted response actions are going to be based on the severity of the incident. So Bill mentioned there's some incidents where it's just sending out an email to the wrong person. That's going to be treated very differently to someone hacking into your server and selling your data on the dark web. So
yeah, absolutely. Thank you.
Having that ahead of time is planning that ahead of time is important. It will make the process a lot smoother.
Hopefully it doesn't happen.
Hopefully it doesn't happen, but it's good to have something in place in terms of knowing. Yeah.
Well, and picking up on that point, I mean, really what we're looking at, and your question is directed to the preventative rather than the curative. So picking up on Christian's points, I mentioned earlier the information audits. From a legal perspective, a lot of the focus of some of the cases, the data breaches that have been experienced, are very much on, holding on to information for far too long when it should have been destroyed. So things that you can do now, and I know that it's all about resourcing and budget allocations, but management working with IT and others about undertaking information audits. They can be done now. You don't have to wait for them. They can be done at a slower time of the business. For example, you can time it where you can get rid of a lot of documents that have been held for more than 7 years. That was one of the allegations with Optus for the AML, CTF, Know Your Client kind of obligations that they had held on to passports and driver's licenses for 20 years.
Wow.
But I'm also going to flip that around and say, okay, we've got 3 examples of cases before the courts regarding data breaches. We've got Australian Clinical Labs, we've got Medibank. Those 2 cases were taken by the Information Commissioner, and we've got the Optus case, which has been taken by the Australian Communications and Media Authority. In each of those instances, they are making reference as part of the allegations to a breach of Australian Privacy Principle 11. Australian Privacy Principle 11 deals with security. And the threshold that they're trying to hold those 3 organisations to is effectively they did not take or did not invest sufficient resources in their security framework, having regard to things like the size of the businesses, the respective businesses, their resources, the nature and the volume of the information. So effectively, the bigger and the more sensitive, the bigger the business and the more sensitive the information, you should be investing more in your security framework. So from a preventative point of view, it is working with your IT teams, with your other teams in terms of investing sufficient resources to make sure they have all the tools available that they need to prevent the more obvious kind of threats that may exist to the business in terms of things like ransomware and attacks. Also, part of that is not only, we appreciate, and the law will appreciate, and we'll see from those decisions what they regard as the benchmarks required for security. No system is impenetrable. So I understand that, and we'll find out more about that in due course from those 3 matters if they go to trial or there's some decision handed down. But the other aspect of that is trying to work out not only cybersecurity training and data breach training, that is, I liken it to like a fire drill, that you do a data breach. Often when we get taught, and when a business gets trained in cybersecurity, they said, don't click on these emails. If it looks suspicious, don't do this, don't do that, but do this. Perfectly fine. But not enough attention is paid to what do we do in the event that there's a data breach. Effectively running that fire drill, which I always find quite odd that you do cybersecurity training, but you don't do the
fire drill. Such a great practical suggestion, Bill, of something that an organisation can do, and they can work out, how they would respond and communicate. I love it, the fire drill. Thank you.
Sonia, all right. Sorry, can I just add one more thing? I think what I've gotten out of this is that cybersecurity and business strategy are not necessarily separate entities. Like they both work together, and cybersecurity helps to enhance the business objective. It's a cybersecurity risk is a business risk. If you can't operate that as a result, that's affecting your business. And I think there's been this disconnect between, letting the nerds do the nerdy things and let the business run in the business side. And I think that, ultimately we all need to work together and work towards what the business outcomes need to be.
Yeah, fantastic. All right. So we're going to move into the Q&A section. Just before we start to address some of the questions from our audience, I'm going to kick one off, even though I've been asking all the others. And this one relates to having ISO certification. So I'm not sure, Bill or Christian, who wants to answer this, but how can having an ISO certification assist in the prevention of an attack?
Bill, I'm not sure if you want to take this one. I can take it.
I'll let you go first. I've talked about information audits, but
okay. So ISO is a standard for information and data governance. There are many out there. So you have ISO is recognized as the international standard, but you do have others like HIPAA for health services. You have the COBIT for security management of an organization, the NIST framework as well. All these different frameworks kind of borrow from each other and do have overlaps. The main thing about ISO is it is a certifying standard, so you have to have an auditor in place to look at what your data governance is and what controls you've put in place to secure your data or information. Having stronger cybersecurity and having stronger data governance over how you're distributing information is only going to help to contribute to your ISO standardization certification. Yeah.
Thank you. Bill, did you want to comment?
Yeah, as Christian mentioned, ISO 27K or 27001 is just a certification. It's an information standard. It goes to how you handle the information and what practices you have, including, retention and destruction processes. It's also got a physical component, how your offices are actually secured, and whether the public would have access to, if they walk past, do you practice in things like, lock screens and hiding documents and locking certain documents away. So there's another component to it, not so much just isolated to data, but it's also information controls within organizations. I'll add to that, no doubt. Christian just mentioned there's a few others. In terms of my clients, some operate in the financial services space. So there's all sorts of regulatory guidance if you are subject to the ASIC Act or the Corporations Act that you have to comply with. So there's CPG, CPS's 234 and others, 235. There's other standards like OWASP, amongst others. So there's a lot of information standards that exist depending on which sector you operate in. Hopefully, if you're especially in financial services, there's quite a few that apply, and often they apply in tandem. So they're out there, and there's a lot of the reason why a lot of businesses invest in getting ISO 27K certification is it gives their customers and other businesses that they deal with confidence in terms of their practices. So there's an aspect of that. It makes good business sense to do it.
Okay, thank you. All right, the questions are starting to be fed through. So I'm going to go with the first one. It's for Bill. It's a question that relates to the education sector, specifically prep to year 12. So it's not a university question. It says, aside from the Australian Privacy Act, what are the key cybersecurity regulations or legal obligations that organisations in the kindergarten to 12 education sector must comply with? It's a very specific one for you there.
Okay, so depending on which state you're in, there's also notification. There's privacy acts in particular states. So Queensland, New South Wales, Victoria all have their own state privacy acts. In WA, there's a bill that's being proposed. In New South Wales, it also has a data breach notification scheme at the state level, and WA is currently proposing that. Queensland is currently consulting about that as well. And the reason why I raise that is because it's not clear whether it's a state school or a private school. There's obviously, if you're part of the education department, there's all sorts of obligations that would exist in those states amongst their state-based acts. Otherwise, if you're regulated not by a state act because you're not a part of the public service, you would have the Privacy Act, the Commonwealth Privacy Act, that would apply. You would also have other obligations under the legislation regulating the education space regarding retention and destruction of information.
This one's in Victoria, I believe.
Okay. So you have, and if you're I'm not sure if it's a public or a private school, but if it's a private school, you'd be regulated by the Privacy Act, as well as other legislation in the education space. So even though if you're not a public school, you're still regulated by certain legislation within Victoria dealing with education, and there's all sorts of information and obligations that apply to schools, even if they're private, as part of their certifications, as part of their
And
registrations
how
of
are they
putting in
enforced?
education.
There was a follow-up question there around how these regulations are typically enforced or monitored.
It's interesting because there's often competing organizations and departments that step in. I've seen data breaches where, the state-based regulator and the federal regulator are both involved at the same time. And they, in the last 2 years, have introduced sharing obligations between the regulators. So there's now a legislative framework where the state-based privacy regulator can share information with the federal regulator and vice versa. There's also scope in the state acts where they can share information with other departments. So say in Victoria, I'd say OVIC, the Office of the Victorian Information Commissioner, would have the ability to share information with the Education Department about data breaches, and it would be a matter of coordination along with the Digital Victoria, which is another level of bureaucracy that steps in to coordinate these kind of things when public sector information is involved. It's anyone's guess who could be stepping in. It could be, if you're in Victoria, I would no doubt expect the Education Department, OVIC, and Digital Victoria to step in and sort of all have questions. And this goes back to my point before, when clients go, well, it's just a data breach. Why would it be expensive? It's like, this is the reason why it's expensive, because there are so many levels of bureaucracy involved. And then add to that, say it was a ransomware attack, we're adding in, the intelligence services into that framework as well now. So,
all right, thank you. All right, we'll move on to the next question. So this one is, how can businesses assess their level of vulnerability to data breaches? Great question. Probably Christian for that one.
Yeah, look, there's different types of assessments we do in certain audits that we can have in place. So vulnerability assessments is generally something that our Netway managed services clients get every month, and it's basically an automated vulnerability assessment and response sort of report, which gives you highlights on what your vulnerabilities are in the environment. But second to that, it's not just about what patches are installed on systems and whether your laptop at home has the latest Windows updates, although that is important. It's more about what sort of what controls you have in place in your organization that and how things are being done. So let's, again, going back to the essential 8, how you're backing up is very important. What sort of MFA controls you have in place? Do you have MFA on your computers? Do you have it on your email? Do you have it on your...
multi-factor authentication for those that don't know.
Sorry, yeah. Apologize, yes. So do you have it on Salesforce or MYB, all of those kinds of things? So we offer Essential 8 audits, so we can go through your environment and have a look at what your technical controls are, what sort of governance you have in place as well to meet those maturity levels. And then we can draft up a report and say, hey, look, you're maturity level 1, or maybe you're getting to maturity level 2 and you say, I'm not sure if I'm there yet. We can have a look and say, yep, if you fix A, B, and C, you'll be at maturity level 2. So those are the two main things that we can do. Yeah.
Thanks, Christian. And I think, Bill, am I right in saying that the more customer data, personal sensitive data that you hold, the more vulnerable you will be?
Yeah, less is better.
Yeah.
Simply.
Yeah.
And I know that the tension that I usually find is that between management and marketing, because marketing obviously wants the biggest data set as possible. And that's often coming up in the privacy sphere where, you're trying to attract business and so forth. But putting aside marketing, yeah, less is better in terms of making sure that you get rid of information after you've passed the threshold of either its purpose has been fulfilled, or any relevant requirements that apply. Corporations Act often has a 7-year requirement for retention of data. The Fair Work Act for certain information has 5 years in there, or 7 years in some other respects. Look at Section 535 of the Fair Work Act. So getting rid of information that you no longer need, depending on which area of law is, which area regulates you, is important.
That leads really well into the next question someone has asked. So, understanding what your obligations are. Someone's asked, can cyber insurance protect me as a director from fines?
Yeah, it's an interesting one because often insurance policies don't respond in the event that it's criminal conduct. A lot of this conduct is not criminal, even if there's pecuniary penalties that apply. It's that hybrid sort of penalty regime, which is not criminal in nature. So there are cyber insurance policies, there are D&O policies that would respond as well. We talked a little bit earlier on about directors and officers potentially being liable. I'm aware that though that hasn't happened to date, it is likely to happen in future. I know ASIC has been big on this and talking about this area of holding directors and officers liable for not investing enough, or not doing enough, or not training people enough when it's their responsibility, trying to hold management accountable for the practices of organizations. That's sort of starting to creep in a little bit. If you look at the data breaches that have occurred in the cases that I mentioned, the clinical labs, the Medibank and the Optus, what's interesting about those cases, at least the Medibank and the clinical labs, it's not only that they didn't take enough steps prior to the data breach, but it's also what they did immediately following the data breach. And that's where I think it's ripe for directors and officers to be held accountable. That is, the way that the business responded under their stewardship, it was insufficient. And I wouldn't be surprised if at some stage, whether it's ASIC or whether it's the Privacy Commissioner, or if it's another organisation, another department, starts looking at that. And one of the examples of that I would point out was what happened with Optus. One of the things that Optus is being criticised, and they're being taken to court by ACMA, as I mentioned earlier, is during their data breach, their comms team and their relevant people were putting out, oh, this is quite a sophisticated hack. It is quite difficult to unravel it, and so forth. What the allegations that have been made by ACMA in that proceeding are is actually it wasn't. It was quite an unsophisticated hack, because there was 2 particular domains where Optus had identified both of them, but only remediated one of those domains, which was left vulnerable for a period of 4 years. They patched it and fixed it in one example, but they didn't patch and fix it in another. And that's where the access, or where the intrusion occurred.
Okay.
And so that becomes a little bit embarrassing for Optus, because they said, oh, it was quite sophisticated, when in fact, according to ACMA, it wasn't. And how that plays out will be very, very interesting. But what that goes to your original point, is the liability of the directors and officers who are making those statements, and what information they're relying upon internally, who's feeding them that information, and why are they saying it, and how they respond to the particular data breach, I think is also very ripe for attention as to holding directors and officers to account.
So proactively looking at who your response team would be, which forensics provider, which legal firm, which PR firm, which IT experts you'd be using, if and when you're subject to this in advance, would be really helpful. All right, we've got another question. It's a final question that's come through. This person has said, I understand there is legislation being introduced to Parliament that will provide the government with the authority to direct firms to address serious deficiencies within their risk management programs. Do you know if this is a blanket rule for all entities, Or are there particular criteria, i.e. if your turnover is greater than 3 million, or the type of data you hold?
I'm happy to address that from a privacy perspective. There's increased requirements that are being proposed. One, amendments to your privacy policies. They're being toughened up in two respects. One, the information that goes there, but secondly, and specifically to automated decision making. So as part of the first tranche of privacy reforms, there's an obligation to spell out if your organization has automated decision makings, you have to spell that out in your privacy policy. The second aspect to that is powers have been given to the privacy regulator to issue infringement notices in addition to court action. That is, to date, if the privacy regulator wanted to commence proceedings, they can commence proceedings in the federal courts, say, and seek penalties. The current maximum are 50 million or 3 times the turnover during the breach period and so forth. So of the benefit obtained during that breach period. But they're seeking to introduce infringement notices. That would, putting those two things together, that means that the regulator can issue infringement notices basically if your privacy policy doesn't meet the relevant standards, is not sufficiently clear. It could mean that if you haven't put in automated decision making into your privacy policy, that could be the subject of an infringement notice, as could be other aspects of non-compliance with the Privacy Act and the privacy principles. There's quite a few that they've spelled out in tranche 1. And these will apply to APP entities. As part of, they haven't dealt with, as part of tranche 1, it's potentially part of tranche 2, removing the $3 million threshold and decreasing it, whether it's to 0 or to another figure or another definition, so that more businesses and individuals and trusts and partnerships are caught by the Privacy Act. And that would mean, obviously, more entities being not only regulated, but having to implement risk management frameworks. So there's a lot to unravel there. There's also expansion into covering employee personal information, which is currently exempt, which would be caught in future either by the Privacy Act or by the Fair Work Act in terms of more privacy regulation. So I'm not sure which specific legislation the person asking the question was referring to, but there's a lot of movement in the space, whether it's in the privacy space. We talked earlier about cybersecurity and risk management there. And there's other legislation that's, that covers, for example, corporations that are regulated under the Corporations Act. So hopefully I've addressed that question in terms of, at least in terms of the privacy. We dealt with cybersecurity earlier.
Thank you. Christian, do you have any final comments before I wrap up?
The only thing I was just going to say, I imagine, given how expensive cybersecurity insurance is just in general, to have directors insurance would likely be more expensive than that. But I mean, I don't know. But just thinking on that before, it was interesting to know that the insurance existed, to be honest.
All right. Fantastic. Thanks, Christian. Well, look, on that note, we might conclude. If you'd like to learn more about where your business is at in terms of your cyber security vulnerabilities or where you stand, Netway does have a quick 2-minute survey. I think we have a slide that we'll just put up now that basically you can scan this QR code. We will also put the link in the chat. Essentially, it's anonymous and confidential, and you can take a quick questionnaire to assess just how vulnerable you might be. So please feel free to take advantage of that. So look, on that note, I'd like to say a very big thank you to Bill and to Christian for joining us today. It's such a minefield of a conversation. I think with the increasing threat of cyber attack, so is coming the increasing complexity around our obligations and also around how we best protect ourselves our organisations and our data. So I'd like to thank everyone today. It's been a really great conversation. We'd love your feedback. Thank you also to the broader Netway team and our marketing team for supporting this webinar. Have a great day, everyone. And if you've got any follow-up questions, please feel free to forward them to us. Thanks again.
Thanks,
Wishing you a
guys.
great day. Bye-bye.
Thank you.
Thank you.